Good morning, students. I am Dr.R.SUGANYA, Assistant Professor, Department of Computer Science with Cybersecurity. Today I am going to talk about computer forensic analysis, that is, discover of electronic evidence, how we can discover the electronic evidence. So, computer technology has revolutionized the way we deal with informations and the way we run our businesses. Increasingly, important business information is created, stored, and communicated electronically. Many types of informations can play a useful role in litigations or no longer printed on paper and stored in paper files but rather or stored in a computer system or in computer readable form. As companies have increased their reliance on their computer systems, lawyers have begun to be aware of valuable electronic treasures that are now being kept in these systems and have started aggressively to target electronic data for discovery in all types of litigation cases. The primary purpose of these provision is to enable the government to determine whether a company is complying with record keeping and other requirements contained in the statute that imposes them. Many businesses are increasingly storing the required records in electronic form. So it is to focus their attentions on only these records and computer systems that house them. So the government also access to records for investigatory purposes. Several statutes such as Human Rights Codes, Competition Act, Criminal Code and Tax Acts give government officials a right to enter a business establishment and inspect or seize records. For example, under the Competition Act, peace officers with or in exigent circumstances without a search warrant may enter the premises, examine records, and copy or seize them. Lawyers representing parties with large amount of electronic data need to be understood that their clients' data will be targeted for such discovery and need to advise their clients on how to prepare. Defensive strategies that should be implemented prior to litigation include a proper document retention program, periodic purging of magnetic media, and the implementation of document management system. Once litigation has commenced, defendants need to be better advised on how to preserve relevant electronic evidence adequately to avoid possible sanctions or a negative inference at trial. Electronic document discovery, a powerful new litigation tool. Other than direct testimony by an eyewitness, documentary evidence is probably the most compelling form of evidence in criminal and civil cases. So often, important communications are committed to writing, and such writings can make or break a case. So, the same is true about documents used to conduct financial transactions. The paper trail has always provided a wealth of information in criminal and civil cases involving fraud. So, we can see many real time events. Okay, we can use a case study too in order to determine which all the things are being a eyewitness evidence. So traditional paper documents have been sought in legal discovery process for hundreds of years in cases involving white collar crime. So in most recent times, no, so we have heard about sexual discrimination, racial discrimination, stock fraud, and the theft of trade secrets. So today's judges and attorneys are very familiar with documentary evidence in paper form. Unfortunately, the legal process has not kept pace with computer technology, and the document discovery rules have changed concerning the discovery of computer created documents and related electronic data. The best evidence rules also work differently today because copies of computer files are as good as original electronic document. From a computer forensic standpoint, this can be proven mathematically. There is no difference between original and exact copy. So this is especially true for the creation of documents on a computer word processor. When electronic documents are created, bits and pieces of drafts leading up to the creation of final document are written in temporary computer files, the Windows swap file and the file slack. The user is usually not aware of this situation. A historical perspective helps one understand the evolution of computer forensics and its transition into the new field of electronic document discovery. So, when computer mainframe giant International Business Machine entered the personal computer market in October 1981, The event quickly captured the attention of corporations and government agencies worldwide. The worldwide popularity of both personal computers and the internet has been a mixed blessing. Powerful personal computers are technology workhouses that increase productivity and provide portability. The internet provides a conduit for the transfer of communications and computer files anywhere in the world through personal computers. Even the disk operating system installed on the original PC was never intended for commercial use. So this for electronic document discovery, like that creates an ideal things for computer files, file fragments, and erased files. Some computer forensic specialists regard electronic document discovery as nothing more than the exploitation of the inherent security weakness in personal computers and the internet. So there are three C's in computer forensics, which is the one of the three. And you are supposed to maintain three types of record, which answer is not a record. Physical forensic discipline includes which of the following? Which is not a step in the scientific method? Which of the equipment don't you have to get ready for recording video? Thank you.